I want to bring in Court TV legal correspondent Julia Janae, who joins us live from Minneapolis tonight. Julia, great to see you tonight. This ruling is, I think, huge because it kind of settles everything now, right? Now we are at a point where it is clear what the charges will be against Derek Chauvin.
It's as clear as both of these parties want it to be. No one is objecting at this point. We haven't seen any filings, so it looks like these are going to be the three charges against Derek Chauvin going forward as we get closer to that date for opening statements, which is March 29th. Today, the lead prosecutor on this case, who we're not going to hear a lot from because he's not going to be the presenting prosecutor, but this case is still in his office. Attorney General Keith Ellison put out a statement in reaction to the judge's decision today on third-degree murder, and he says that the charge of third-degree murder, in addition to manslaughter and felony murder, reflects the gravity of the allegations against Mr. Chauvin. We look forward to presenting all three charges to the jury. And the thing about the third-degree murder charge that stands out to me for Hennepin County, where this case is happening, is this case, the prosecutor's office here, the county attorney, they've been proud of the fact that their office has handled one of the successful convictions of a Minneapolis police officer. That was Muhammad Noor. And in that case, a jury came back with a conviction for third-degree murder only. So likely significant for this prosecution team to know that they now have that on the table going forward.
And it's important in many aspects. Number one, it could be the way the jury comes to a conclusion about the mindset of Derek Chauvin at the moment that all this is happening, what his intent or lack of intent was, exactly what his actions entailed. It also gives them choices. And we know from experience, Julia, that sometimes jurors don't agree. And like anyone else, when you disagree, you can compromise and meet on some middle ground. So this gives jurors who perhaps are in disagreement a landing ground and two options for murder and one for manslaughter. And I think that word murder is probably significant and important for prosecutors and for the victim's family in this case.
It does give them more options. I've had the opportunity to talk to jurors after they have finished their deliberations, and some will admit that they were on opposite sides as far as what's happening inside that deliberation room, and sometimes they do just settle on a second-degree or third-degree murder charge because the ones who believe it's first-degree or second-degree murder don't want to come over to the side of those who may be on the fence even about guilt or innocence. So it is more options. We know the state is the one who's been pushing for this, even though oftentimes we see the defense asking for lesser included charges to be on the table. Now, the judge today talking more about his decision in this, and that even though he didn't agree with how the Court of Appeals came to their decision to say that he had to follow Muhammad Noor, he did say he would accept it.
Yeah. Absolutely. And it seems that he still disagrees a little bit with part of the reasoning and what they came down with. But I get it. I get it. So the other part of this, which is a possibility, the Noor decision, which is controlling the judge's decision to reinstate this third degree, is also up in the air in the Noor case. Is that going to the Supreme Court? Is there any chance that that could be overturned, the precedent that this judge is now following?
It could, because the Noor case now sits with the Minnesota Supreme Court. But the Supreme Court ruled separately, or rather the Court of Appeals ruled separately, that their decision is final at this point, even though the Noor case is now in the Supreme Court. The Supreme Court has accepted it. They will hear arguments on that case in June, but we know that'll be long after we get a decision in this case, whether it's a conviction or an acquittal, whatever the case may be, that will be done. So likely whatever happens in the Noor case in June won't impact the Chauvin case, but some legal experts do say that could be an issue that will come up on appeal.
It could, because here's the scenario, right? Let's say the jury comes back and finds Derek Chauvin just guilty of third degree, and then the Supreme Court of Minnesota overturns the third degree conviction of Noor and disagrees with the appellate court. Then, of course, Chauvin's attorneys would then say, listen, now there's new precedent in this case, so you've got to dismiss the third degree, and then prosecutors will be left with no conviction for Derek Chauvin. I mean, that's a wild situation that may not happen, but it is a possibility.
It could be. It's unclear if it would be retroactive in that way, but because it is part of this litigation coming up to trial, the defense is trying to keep third-degree murder off the table for all of these reasons and has been turned down. It could be a way to bring it up on appeal because it's not something that happened long before this case. It is something that is happening while this case is actually about to go to trial. There's also the issue of how it changes third-degree murder here in Minnesota. The traditional interpretation appears to be that it only applies when someone is doing something inherently dangerous to a lot of people. Eminently dangerous, rather, is the quote from that statute. But now the Court of Appeals, and following the Court of Appeals ruling, Judge Peter Cahill in this case, has to agree that it can be applied to something where there's just one victim, and that's the sole subject of whatever the crime is. Now, Judge Cahill, he actually talked about the difference between these two cases. Take a listen.
Under Knorr, if you look at the facts of Knorr, it's Minneapolis police.
I think they are different, Knorr in this case. I said so in the original probable cause order. Said we could understand how Knorr falls under third-degree murder because firing a gun out the window endangered not just the person who was killed, but also that officer's partner, biker who was going past at the same time. And so that was clearly fit in the universe of depraved mind, danger to others, plural.
Right.
And I think the distinction we made in the original probable cause order last fall was this is a different case. It is more focused on a single person. And clearly I said the single person rule applies or doesn't apply depending on how you state the rule. And basically there has to be more than one person endangered by the conduct. The Court of Appeals in Knorr said they did not take the route of saying we don't have to reach the single person rule because it did endanger others, not just the victim who was shot. They didn't take that route. I think they didn't have to, but they didn't. They said single person rule. When the animus is directed at a single person, that's enough. It falls within the gambit of a third-degree murder charge. So I agree they are different cases, but it seems, if anything, this is more the single person rule application, even more than Knorr, and I'm not sure why they felt the need to decide it that way, but I'm not questioning the Court of Appeals.
Vinnie, we talk about how the death of George Floyd has shaped and changes the criminal justice system, but we're also seeing now how Derek Chauvin's case may be shaping the law and the interpretation of it here in Minnesota.
And getting back to the third degree, I thought there was an interesting argument made by Eric Nelson today, which is one he'll probably make to the jury on this charge, talking about third degree. Let's take a listen.
Under Knorr, if you look at the facts of Knorr, it's a Minneapolis police officer. This is a case involving a former Minneapolis police officer. And that's about where the similarities end. And if you look at the line of cases, Knorr, Middich, Hall, all three of those cases, there's some sort of an instrumentality that is used, a gun or a car, generally speaking. Those items could be viewed as inherently dangerous. So in Knorr, right, they're saying what I understand Knorr to stand for is the single person rule, and whether a single person can be the focus of the third degree murder. But in the Knorr case, Mr. Knorr shot his gun across his partner's chest towards a silhouette that could have been anyone or anything. They just saw this biker. Anybody within the line of travel of that bullet was put at risk. It happened to be a single person that was there. And I think that that's significantly different factually from what is alleged in this particular case. They are alleging that my client did not do something inherently dangerous. It was focused on a single person. So factually, these cases are considerably different.
And Julia, in making that argument, I think where he's going, and I tend to agree, is that the action of Chauvin is not imminently dangerous the way the law defines imminently dangerous. He is doing, in some respects, what he was trained to do to subdue a suspect, right? You could argue, I think, very clearly that no, he crossed the line. He was intentionally harming him. That's second degree. It fits there. He's doing what he's trained to do, but he's not doing it correctly, or he's doing it too long. That would be the level of negligence or culpable negligence, criminal recklessness. To me, that is manslaughter. But to say that putting your knee on a neck while you're subduing a suspect is imminently dangerous the way the law prescribes it would mean that the Minneapolis Police Department was training people to do something that was imminently dangerous. And to me, that doesn't really fit into what we usually think about going back to law school when we talk about this depraved indifference. It's things like firing a gun just in some random place or driving your car through a crowd of people, not doing what you're trained to do as an officer. To me, while you go second, third manslaughter, to me, the facts don't seem to fit with what we traditionally talk about as being imminently dangerous the way the law describes it. Your thoughts on that?
The state is going to be bringing in to counter that the idea that they were trained to turn people over after a period of time, that they were given guidance on that. There's one complaint against Derek Chauvin, or a prior incident where he was involved in the arrest of a man who was on his stomach, was dealing with the abuse of drugs, but that they turned him over, and people told Chauvin and other officers that you saved his life. If you had not have rolled him over onto his side quickly, then he could have died. So the state is hoping that these jurors will see that as him having knowledge that this was eminently dangerous, because he knows firsthand that someone can die if you don't act in a certain way when you're arresting someone in that position.
Yeah, and I think that would go much more strongly to the argument and fit for the second degree. On one level, that he's purposely not doing that, right? He's intentionally not doing that because he wants to assault him, he wants to hurt him, or he is just negligently applying his training. So we'll see. But I think that little argument today by Nelson was kind of tipping us off the way he's going to argue in front of this jury.